here this afternoon for the 5th anniversary of Association for India International Mediation and Arbitration Services. I thank the team of AIIMAS for organizing this event today that brings such visionaries together under one roof on this joyous occasion to celebrate the transformative process of mediation. I am deeply honored by the presence of such eminent dignitaries today, whose contributions to law and justice inspire us all. Your presence here reflects a shared belief that mediation and the area are not just alternative but essentially pathways in achieving real and lasting justice. I would also like to extend my heartfelt congratulations to all the awardees today, that is judges, mediators, academicians and professionals for their hard work and unwavering dedication to the promotion of peace and understanding through mediation. Your efforts remind us that the justice does not always arise from a verdict, but also from a conversation guided with patience, empathy and good faith. The occasion is not only a celebration of the achievements of the AIIMAS, but also a moment to reflect upon the growth of alternative dispute resolution in India. Our judiciary, despite its unwavering commitment, carries an overwhelming backlog of over 5 crore cases pending across various courts, with 90,000 cases pending in Supreme Court itself. Justice delayed often becomes justice denied, and in this context, ADR has emerged a ray of hope. It is not merely an alternative to the litigation. It is more humane, efficient and participative way of achieving justice. ADR embodies collaboration over competition, resolution over rivalry and peace over prolonged proceedings. The Supreme Court in the landmark case of Afghans Infrastructure Limited understood the revolutionary potential of Section 89 of the Code of Civil Procedure, which empowers courts to refer matter to the arbitration, mediation, conciliation and other non-adjudicatory processes. This judgment marked the beginning of a new era where ADR became an integral part of India's justice system, not a peripheral experiment. Today, ADR is no longer viewed as a secondary or supplementary. It is recognized as an essential pillar of justice, one that only saves time and one that not only saves time and cost, but also preserves dignity, privacy and relationships. Among all the forums of ADR, that is arbitration, mediation, conciliation and judicial settlement, mediation holds a truly special place. It is not about winning or losing, but about listening, understanding and finding common ground. Mediation is voluntary, confidential and rooted in trust. It empowers parties to create their own solution, guided by a neutral mediator, ensuring outcomes that are not imposed but owned. As Supreme Court observed in Perry Consagra, the strength of mediation lies in its confidentiality. Parties can speak openly, knowing their words will not be used against them later. This sense of security allows truth, emotion and empathy to emerge, often leading to solutions that even the most reasoned judgments cannot achieve. Mediation's relevance extends beyond dispute resolution. It fosters community peace, corporate governance, women's empowerment, environmental protection, and even international diplomacy. It reduces burden on courts, strengthens public confidence in justice, and contributes to social and economic progress. In recent years, India has witnessed a remarkable rise in mediation awareness and practice. Court and mediation centers across the country have resolved lakhs of disputes achieving impressive settlement rates. The growth of online mediation has further expanded access enabling parties to resolve conflicts from anywhere in the world. Today's mediators are addressing a wide range of matters, from commercial and family dispute to those involving banking, real estate, employment, intellectual property and community issues. The Act of the 2018 amendment to the Commercial Codes Act, in terms of Section 12A, introduced compulsory pre-institution mediation for commercial disputes, except where urgent relief is sought. This marked a turning point in India's commitment to shift towards a non-adjudicatory resolution process. The Supreme Court in Patil Automation affirmed that the pre-institution mediation is mandatory and any commercial suit filed in violation of this mandate is liable to be rejected under Order 7-11. A contrary interpretation would defeat the very intent of the legislation, that is to ensure that parties first explore alternative means of resolution, and only the most genuine cases reach courts. This instance further was reiterated in the recent judgment of Dhanbad Foods Private Limited delivered in 2025 only, where the Supreme Court has cautioned that exception in the form of urgent interim reliefs cannot be misused as a mere excuse to bypass Section 12A. Where Section 12A is confined to commercial suits, Section 5 of the Mediation Act 2023 formally extends compulsory pre-litigation mediation to all kinds of civil suits. The enactment of Mediation Act 2023 is indeed a watershed moment in India's mediation trajectory, taking us long ways towards formalizing and promoting mediation practices in the country. Significantly, Section 27 of the Act of 2023 grants the force of a court decree to the mediated settled agreements, ensuring their enforceability. The Act also recognizes the role of technology in dispute resolution through online mediation, maintaining both confidentiality and security. This not only modernizes the process but also extends access to justice for citizens in remote and socio-economically weaker regions, thereby supporting the constitutional promise of equal access to justice. Importantly, the Act allows parties to choose mediators of any nationality under Section 8, thus enhancing flexibility and party autonomy. Promoting institutional mediation has been one of the major agendas ahead. The Act and establishment of Mediation Council of India is a strong move entrusted with creating a robust and credible mediation ecosystem. Its role spans accreditation, standard setting, training and public outreach. All things critical for a system that aims to earn professional and societal trust. Dynamic organizations like the AIIMAS are brilliantly advancing this vision, and their contribution is truly commendable. Yet for me, the most remarkable inclusion of the Act is community mediation. It brings us closer to India's traditional roots, where since ages, elders and panchayats harmoniously resolve disputes within communities. This provision allows families and the residents of an area to amicably address conflicts with support of the respected community mediators and help revive a legacy of harmony and equity. India's ratification of Singapore Convention on Mediation aligns with international standards, facilitating smoother cross-border dispute resolution and easing enforcement of mediated settlement agreements across borders. However, I believe in order to really put us on the world map of a global mediation hub, Mediated settlement agreements resulting from proceedings conducted outside India must also be enforceable under the Act. This is one critical limitation within 2023 Act which creates an uncertainty for parties trying to enforce foreign mediated settlements within India. With a rising number of complicated cross-border transactions and the growing attractiveness of mediation, India must enable enforcement of such settlements, perhaps through a mechanism similar to approach used for foreign arbitral tribunal under the New York Convention. While our mediation framework is still evolving, we can learn from the leading mediation jurisdiction like Singapore, which has pioneered innovative hybrid models such as ARB-MED-ARB and LIT-MED-LIT. These allow disputes to seamlessly transition between arbitration, litigation and mediation depending on the progress of a particular case. This ensures procedural flexibility while retaining enforceability mechanisms and are especially valuable for complex commercial disputes. However, despite all kinds of innovations and developments, a major challenge lies in the mindset. What really needs to be targeted to bring about a real shift towards mediation is the attitude that the general public carries about it. People still do not take mediation seriously, and in spite of statutory mandate of three-institution mediation, it is more often treated as a mere procedural formality, something to quickly tick off before litigation begins. If parties and their counsels are not participating in mediation in good faith, the entire process is rendered ineffective and more of a tokenism step. Citizens must understand that mediation is faster, cheaper and more humane. As mediation has all the ingredients to robust alternative dispute resolution device, investing in the right kind of technology and infrastructure can really strengthen public trust in the institutional reliance. The way our courts are flooded with the cases at this point, it is imperative to take right steps towards investing in all kinds of areas. Many border and remote areas still lack sufficient mediation facilities. Strong technology integrated centers must be established at all levels to genuinely deliver justice at the grassroots level. At the same time, but it is great to be able to choose from foreign mediators under the 2023. We should acknowledge the significant shortage of trained mediators in our country. We need to have a dedicated bar for mediation, and young lawyers must view mediation as a viable and rewarding career path. Efforts needs to be pumped into training an adequate number of mediators under the supervision of every High Court and at state judicial academies. It is indeed heartening to note that AIIMS is actively working towards goal by imparting training to the mediators countrywide. Another point which I would like to highlight is the effort should be made to promote mediation in regional language. As Nelson Mandela has said, if you talk to a man in a language he understands, that goes to his head. But if you talk to him in his own language, that goes to his heart. Thus, mediators in all state and mediation contexts must be well versed in regional languages to be able to arrive at outcome that resonate with the parties personally and give them a sense of satisfaction. Institutions like AIIMAS are truly pivotal in nurturing skilled mediators and promoting peaceful conflict resolution. In present day, India is at the forefront of mediation practices and not just a follower. I am staunch advocate for mediation and all forms of alternative dispute resolution. Our aim must be much larger than reducing the burden on courts. We must build such effective, accessible and trusted system that parties, after resolving disputes through mediation, never feel the need to approach the court at all. Before I conclude, I would like to express my sincere congratulations to the Board of Directors, trainer mediators and members of AIIMAS for their tireless, groundbreaking work over the years towards promoting various forms of alternative dispute resolution throughout India. In just 5 years, AIIMAS has established itself as a dynamic and credible platform dedicated to the advancement of mediation, arbitration, conciliation and other forms of dispute resolution. Its commitment to promoting dialogue, harmony and justice without conflict truly reflects the spirit of access to justice for all. The efforts of AIIMAS in training over 400 mediators nationwide is truly laudable. It has trained lawyers, students, social workers and other professionals through a number of arbitration and conciliation workshops. I believe that one of the most notable achievements of AIIMAS that has been its training projects for the Indian Army, which have introduced officers from India and other friendly nations to the ideas and practice of mediation and conciliation. This initiative truly demonstrates that the principles of peace and dialogue transcend all boundaries. I really admire the humanitarian efforts by AIIMAS, such as Save the Date project, which provide premarital counseling to couples in order to avoid marital dispute in future. The institution is a shining example what can be achieved when a group of professionals share one purpose to replace conflict with conversation and confrontation with compassion. Finally, I express my sincere gratitude to entire AIIMAS team for giving me the privilege and honor of addressing the gathering of distinguished minds who are shaping the future of mediation and peaceful conflict resolution. I wish AIIMAS continued strength, purpose and success in the years to come. Jai Hind, Jai Bharat.